Landlords in the state of New York. Many of you are confused as to whether or not you can proceed with a non-payment eviction here in New York due to the passage of the new New York State eviction moratorium that is set to expire on January 15, 2022. And the answer to that question is this is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. The answer is yes. You can proceed and take them to court for non-payment of rent. But before you do, we warn you. Landlords, this law is 71 pages long. It is very complex, convoluted, confusing, and critical. A social media colleague and I, Vitaly Volpolo of Succeed REI, on September 9th, did a live show for 4 hours going over only a few aspects of this law. Like I said, it is complex. Now more than ever, we advise landlords to not represent themselves in these cases anymore, because you run the risk of making a mistake, a procedural error, or anything such as that, and getting your case dismissed. Now this law, like I said, is 71 pages long. It allows you to take your tenant to court for non-payment of rent. But there are many, many other steps in that process that can hinder getting your tenant out. And we're going to go over those here now. Now, when this new law came out, our team at the Landlord Advocates analyzed this law. We had to draw up, not 1, not 2, not 3, but 9 new additional papers that have to be served upon the tenant and or the courts, depending upon what stage of the eviction you are in, and whether or not your tenant signed the declaration of hardship. We're going to walk you through that entire process, and there are forks that are in the road that will divert you to whatever paperwork you need and whatever it is that you need to do in court at that time to get your tenant out. So you can still have sent to your tenants what you call a 5-day notice, or the rent reminder. That is a notice telling the tenant, you owe me rent and I'm likely to pay me. Thank you. We think that notice is ridiculous, but it is required under the Housing Stability and Tenant Protection Act of June of 2019, that you must remind the tenants that they owe you the rent. Now, when that notice is given to them, sent to them, it must include the declaration of hardship, 3 pages long. First page is the cover page for the Unified Court System. Other document that must be included is the Notice of Legal Service Providers. The following day, you can give your tenant a 14-day notice. When I say you, I mean your process server. We have served upon your tenant the 14-day notice with that declaration and the Notice of Legal Service Providers onto your tenants. Now let's say 2 weeks after that, your tenants do not give you back the declaration of hardship. You can apply for the court date with your summary proceeding documents, copies of your 14-day rent reminder, affidavits of services, proof of mailings, the declaration of hardship, the Notice of Legal Service Providers, a stack of paperwork. With that must be included a sworn affidavit by you, the landlord, or your attorney, attesting that you have not yet received the declaration of hardship back from your tenants. At that point, all of those documents will go to the court, and you will get a court date. Now, let's say you're in court and your tenants do not appear. The court will then set it down for a default hearing, at which point your tenants must be served more documents to come to court on whenever the date of that hearing is, and you have to serve that upon them, have that served upon them, telling them that they missed the last court date and you're asked to come to court for this new court date. Doing that, you shouldn't do that? No, that's ridiculous. The tenant should have come the first time around, and if they don't, you should have been able to get the warrant of eviction and the judgment for the money that was owed to you. That's what you should get. Now let's say your tenant does come to court on the first court appearance, and they sign the declaration of hardship and they give it to you. What should happen is your attorney should have, in the one hand, taken in the declaration, and in the other hand, served a subpoena upon your tenant for records and data pertaining to their allegations of why they had the right to sign the declaration of hardship. We're going to get into that subpoena, that judicial subpoena induces tecum, in a few moments. Now let's step back to that fork in the road and say that your tenants did give you the declaration of hardship. You have to ask yourself, can you challenge this declaration? Yes, you can. But you also have to ask yourself, do you have enough evidence that you believe that your tenant signed this declaration without having the rights to do so? Now, the government calls it the certification of the declaration. There is no certification of it. It is not embossed. It is not notarized. It is not witnessed. It is not sworn to. The law says that if the tenant signs it without good faith, they can be charged under penalty of law, which is ambiguous at the very least. Whereas you, the landlord, will have to sign any document that you have under penalties of perjury, which carries with it a specific penalty, fines, or possibly imprisonment. That does not hold true for the tenant. Of course, this is New York State. What would you expect? Now, your tenant signs the declaration. You say, I am going to challenge this. This is before you get the court date. When you get that court date, all those other documents that we mentioned before have to accompany it. But also what must accompany it is an affidavit that you in good faith believe that your tenant did not have the right to sign that declaration of hardship, and therefore you wish to challenge it. But also, on top of that, is another document that states that you are telling the tenant that you do not believe that they have the right to sign that, and that you're going to challenge that in court. And that during that time frame, they cannot be evicted until it goes to court. This is a sheet that must be on the top of all of that. The government calls it the cover page. Here is where it can get procedurally dismissed upon you. If that cover page is literally not on the top of the summary proceeding document, which is actually on the top of all the documents that are served upon your tenant, technically and procedurally, your case can be dismissed, because that letter that sits on the top is somewhere in that mix of the 5,000 pages that you have to serve upon your tenant. That in and of itself, legally and technically, can get your case dismissed. So now you are here getting ready to serve your tenants. I have served upon your tenants all of those documents. But here is where we mention the judicial subpoena induces tecum. You look at the declaration. Did they sign Part A, which is financial, or did they sign Part B, which is health-related? Or did they sign for both? Most judicial subpoenas induce tecum. Only half a page. That's it. Only half a page. With very little wording on them. When you have that served upon the tenant, that can be construed as ambiguous. I didn't know what you asked for. I didn't know what you really wanted. And that can extend your case out even longer. What we suggest is to hire, like I said earlier, a professional firm to help you with that. Our attorneys at Ideal Legal and at the Landlord Advocates comprised a 5-page, that's right, a 5-page judicial subpoena induces tecum to be served upon any tenant that signs that declaration of hardship. Our judicial subpoena is intimidating, it's obnoxious, but it's legal. It is such that the tenant will look at this and probably throw their hands up in the air and say, I just can't. I just can't. It's asking for so much that I just cannot provide it. And what happens there, landlords, is that when you go to court and they do not provide it, the court must rule in your favor. Because when the tenants do not provide the documentation that you are seeking, then the court must presume that the tenants are not doing so because they believe that the information that they have provided to you is detrimental to their case and that they will lose. But by not providing that information to you, they will lose. Now, hopefully when this happens, the courts will rule in your favor. When this occurs, when your tenant signs the declaration and you are getting ready to have the court paper served upon your tenant, that judicial subpoena should be attached to all of those documents as well. So that when you come to court 12, 13, 14 days later, and the tenant does not have the documents that you are seeking, the court should grant you the eviction, but they probably won't. Because your tenant can say, I want a trial, and the court must give that to them. And that trial could be at least 2 to 3 weeks later. Hopefully the tenants will come to court with all of that. Now here in landlords is where a big problem occurs. The ERAP, the Emergency Rental Assistance Program. Most of us know what that's all about. Is that the tenant applies for rental assistance, you apply for that rental assistance, and then the government will determine whether or not the tenant is eligible and send you a denomination of money. May not be all that is owed for the 12 months back, 3 months going forward. They may not, but they will send you the money in due time for the money that's owed. When this occurs, you cannot evict for non-payment of rent. So during this whole process of refuting the declaration of hardship that your tenant has done in a non-payment case, you can sign up for the ERAP program and it will halt the eviction right then and there. How fair is that? It's not. Because we had done a video on ERAP, and we will have a link to that above at the end of this video that you can click on and watch. The problem with the ERAP program is so far as of September 20th, 2021 today, we have not heard from our social media family or off social media family, a whole thousands and thousands of landlords, that they have received any notification from the government that the tenants have been denied for ERAP. When they are denied, you can move forward with the eviction. But yet no one yet has received any information that the tenants have been denied. And there's no statutory limit on when you are notified. So this can go on for months and months, as it already has for some landlords, for many landlords, who applied in June and yet have not heard anything, or they have heard pending or under review. That's ambiguous. Pending can be forever, under review. What are you under reviewing for? The problem with this, as well as we have learned from tenant advocacy groups, is that your tenants fill out the application for ERAP and they omit documentation, whether they're doing it on purpose or not. You're given approximately 10 days to provide the information that is lacking. If they do not, your application is turned away, shut down, terminated. You and the landlord might say, great, now we can proceed. No, that's not the case. Why? Because your tenants are given another opportunity and another opportunity and another opportunity to apply for ERAP. All the while, knowing that they may very well be denied based upon their income. And even if they are accepted, all the while knowing that they cannot be evicted until a determination has been made. And all the while you, the landlord, are going farther and farther into debt because your tenants have not paid rent for months and months on end. So in summary, yes, you can challenge the declaration of hardship. Yes, you can go to court and say your tenants are not suffering. They receive all this unemployment and stimulus money. They are working. There is no reason why they can say that they're suffering under COVID. They cannot pay rent, therefore they cannot be evicted until sometime in March, April, May, June, and for some areas, like New York City, your tenants may be there the day before you sit down to Christmas dinner 2022. That's not fair, but it is what the law is here in New York State. But landlords, because of how critical and convoluted and confusing this new eviction moratorium is, and that all the processes that must be done through this, we highly advise that you hire professionals to help you from A to Z. Because you do not want to see your case dismissed. Should you have to do this? No, you should not. But it is highly advisable that you do. Swallow the pill, swallow the agony of having to pay for this and endure this. But the government of New York State has brought this upon your shoulders, and allow professionals to help you alleviate that pressure and get you the covenant warrant of eviction that you so want, and to regain the property that you need to. Landlords, we ask that you subscribe to the Landlord Advocates. We ask that you hit the notification bell that you will be made aware of future videos. Hit the like button and share this video with your friends and colleagues and fellow landlords so that they can be as educated as you are now. Until then, landlords, take care.